Welcome once again to Lehto's Law. Here's Steve Lehto.
I did the video the other day about the guy who was eating in the restaurant, and he had ordered boneless wings, and one of the wings contained a bone, and the bone put him in the hospital, and filed a lawsuit under several different legal theories, one of which was negligence, and one of which was breach of warranty. And by the time it got to the Ohio Supreme Court, they were only arguing about negligence, and the Ohio Supreme Court said, well, you know, people who eat chicken should know that it could contain bones. Therefore, you can't file a lawsuit for that in the sense that this won't get to a jury. A judge can just throw this case out. And there's a lot of debate on that issue, but I had several people ask me, Steve, so can they take that and appeal it even further? And I said, probably not, because this is simply a straight state law case, and the issue is state law. And it's not something the U.S. Supreme Court would be handling or a federal court. But the point is there anything that can be done? And yes, the answer is you could fix it with legislation. And so in the couple days since that story broke, a whole bunch of people have sent me a note and said, Steve, check this out. Lawmaker takes action after Ohio Supreme Court rules that boneless chicken wings can have bones. Now, this is the thing. In my mind, this law is not necessary because there's already a law in the books that says that. It's called an express warranty. I talked about that in the last video. However, this is a great example of how, even though there's something on the books, it's apparently not like in your face enough to where you can argue it. So sure, maybe this will help. From the Ohio CapitalJournal.com, Morgan Trow wrote this. The Ohio Supreme Court ruled that a man who ordered boneless wings should have expected bones to be in them, denying him a jury trial after he suffered major injuries, including several surgeries and 2 medically induced comas. A state legislator is so outraged by that decision that he plans to propose a bill to change the law. This is State Senator Bill DeMora. He's an avid wing fan, having weekly wing nights with his friends when he was in college. Just recently, he went to an all-you-can-eat boneless wings event. He said, I did not expect to have a bone in my boneless wings. And the question is that expectation reasonable? And I think it is. But, of course, that's not how the state Supreme Court sees it. Back in 2017, just a reminder, Michael Berkheimer ordered boneless wings at Wings on Brookwood in southwest Ohio. The menu of the restaurant was included in the court documents and did not feature any disclaimer saying that there could be bones or bone fragments in the food. And meanwhile, somebody checked and it still doesn't say that. So he had cut his wings up into thirds, eating the first 2 pieces of it normally. On his third one, he felt something go down the wrong pipe, court document said. He ran to the restroom and tried to expel what was in his throat unsuccessfully. That night, he developed a fever. For the next 2 days, he couldn't eat a bite of food without getting sick. So when his fever hit 105 degrees, he went to the ER. Doctors found a chicken bone in his throat. Now, this was 1 3/8 inch long. And from there, he developed a massive infection in his thoracic cavity. Now, a lot of people are saying, Steve, it's not possible to swallow a bone that size without knowing it. You should have known that before you put it in your mouth. 1 3/8 inch is not exactly huge, but it was there and it caused this injury. The severity of the infection, which centered on his heart and lungs, required several surgeries, 2 medically induced comas, a week-long stay in intensive care, followed by 2 to 3 additional weeks in the hospital. The medical issues are still ongoing. He sued the restaurant and the chicken suppliers, arguing that the seller's negligence led to his injuries. In case you're curious, it's described in some of the legal pleadings that it turns out the chicken suppliers actually x-ray their wings. Not the wings, but the chicken meat is being processed, because these weren't actually wings. I believe this is chicken breast, but that's not the point. The point is the chicken meat is being processed. It's actually x-rayed. It turns out, I believe the allegations are, that this got missed. They didn't catch this. And also, there may have been other people who were hurt by bones, or complaints at least, of bones in that batch. But there was no recall or anything like that. So the Butler County Court of Common Pleas and the 12th District Court of Appeals sided against the man, arguing that common sense dictated the presence of bone fragments in meat dishes. And again, they said you can't even get this to a jury. On Thursday, the majority of the Ohio Supreme Court ruled that the lower courts made the right decision, denying him the ability to continue his lawsuit to a jury trial. The court was split 4-3. It's a close call. And I had a lot of people say, Steve, but what if he didn't really get injured there? He got injured someplace else. What if people start throwing out these hypotheticals? And none of that's in the story, but the point is that that's what juries do. Juries figure that stuff out. So if there's a defense such as it wasn't a chicken bone that hurt him, it was something else that hurt him, well, they can raise that in trial and let a jury decide. Juries decide facts, but the point is you got to get to a jury first to have a case. If they won't let you get to the jury, your case is done. So the justices were supposed to decide whether or not it could go to trial, and that's what a law professor is pointing out. The majority said, no way, this case shouldn't go to trial because no reasonable consumer would think that boneless chicken wings might not have bones in them, especially since bones are part of chickens. That's what the professor's pointing out. The court didn't believe that a jury could rule in the man's favor. Now, in the majority opinion of 4-3, the justice wrote that the restaurant wasn't liable when the consumer could have reasonably expected and guarded against the presence of the injurious substance in the food. And adding that the boneless wings are a cooking style, according to the opinion. He compared boneless wings to the food chicken fingers, noting that people would not actually think they are eating fingers. Yes, that's absurd. The courts used what they call the Allen test to determine negligence. Again, they're talking negligence, which evaluates both if the harmful substance was foreign to the food or natural and whether the customer could reasonably guard against it. They found that the bone was natural and large in comparison to the piece of chicken. Any reasonable consumer should have been able to find it, the judge wrote, explaining the court's decision. By the way, I've spoken to people quite familiar with this case. And the man was not at that table by himself. There were other people at that table. And I'm going to throw out a fact that's not in the case here, but it is a fact nonetheless. There was a younger person sitting at that table who ordered the exact same dish. And if they had simply switched the dishes, and the kid had gotten the food, and the kid had been in the hospital with a fever of 105, and the kid was put in 2 medically induced comas and spent time in intensive care, are you telling me they would have said, oh, kid should have known that? Does it really make a difference if it's the adult or the kid, and it's just a matter of who got which plate? Meanwhile, the dissent was emphatic. The result in this case is another nail in the coffin of the American jury system. The case is merely about whether the plaintiff can have a jury of his peers decide if the restaurant and suppliers were negligent according to the law. So the idea that the label boneless wing is a cooking style is jabberwocky, said the dissenting judge, saying the absurdity of the opinion reads like a Lewis Carroll piece of fiction. Now, don't forget that this could have other effects. So, for instance, people who are nut, dairy, or gluten-free, court seems to be saying that if they order allergen-free food, it could still have the allergens because that is natural to the food. Now, here's the thing. The majority opinion addressed that in their opinion because they read the dissent. They said, okay. They said that question is not before us right now, which is something they often say when they want to sidestep an issue. But isn't it true that everyone should know that there could be peanuts or peanut dust or something in food? Because food gets prepared and stuff gets mixed together, and that's natural, right? So, unlike the presence of the bone in this case, the presence of lactose or gluten in a food that was advertised as being free is not something a consumer would customarily expect or be able to guard against. Well, yeah, we'll see how that plays out. So, the politician said this is insane. This defies logic, it defies reason, it defies common sense. Now the definition of boneless means it could have a bone, according to the Ohio Supreme Court. So the lawmaker says you get screwed out of your day in court because we have to protect our donors and our corporations more than we protect our citizens. And by the way, I mentioned at the end of my video that I do believe that this is a political issue because unfortunately, a lot of these cases are looked at as being either pro-business or pro-consumer, as if consumers and businesses are always adversarial to each other. And I don't know why you have to treat a restaurant as being adversarial to its customers, but that's what it often looks like by the time it gets to a Supreme Court. So the lawmaker has already directed his team to start looking into what they can do to help Berkheimer and other Ohioans. We can't really pass a law saying that boneless chicken means there's no bones in it. Although maybe we can. I don't know if that's possible. I'm going to do it. Regardless of that idea, he's also researching other consumer protection provisions that he can draft bills around. And Berkheimer's attorney agreed that this case wasn't fair. He said, I believe that his dissent correctly wrote that the ruling was another nail in the coffin of the American jury system. Mr. Berkheimer suffered catastrophic injuries from a bone contained in a menu item unambiguously advertised as boneless at every level of commerce. All we asked is that a jury be able to make a common sense determination as to whether he should be able to recover for his injuries. But the court's majority ruled otherwise, simultaneously denying him that opportunity and rendering the word boneless completely meaningless. And so, there's more to the story than that, but I'll stop. I've spoken to several people on this case, and I even had someone send me the plaintiff's brief on appeal. And I read their brief, and I said in my original video, I don't know what happened to the argument regarding the express warranty, because the Uniform Commercial Code talks about the sale of goods and actually talks about the sale of food. And so when you go into a restaurant and buy food to be eaten on the premises, that food is considered to be goods under the Uniform Commercial Code, which means that everything applies to the sale of goods applies to that, such as an express warranty. And so there's several different kinds of warranties. You get an implied warranty of merchantability, implied warranty of fitness for a particular purpose, and the express warranty. An express warranty is the simplest one of all. It simply says that if I make a statement that describes the goods and you rely upon that statement, and it turns out that my statement is false, that's a breach of warranty. But it's got to be the kind of statement that's measurable. And I said before, I showed you something that said, this weighs 1 pound. And you buy it doesn't weigh a pound. Guess what? Breach of warranty. And I've had people go, wait, really? For something? Yes, if it's measurable and it hurt you financially, okay? And so there's all kinds of these things that pop up. Just if you make a statement about the goods and the buyer relies upon it. So let's back up to the transaction that took place at tableside when there's somebody taking your order. And let's assume that that was a negotiated transaction. It's not. Somebody looks at the menu and they place an order. Let's assume it's negotiated, okay? So I have the menu in my hands and the waiter or waitress walks up and says, what would you like to order? And so I got a question for you. Boneless wings. Do they contain bones? The waiter or waitress would laugh at me and go, of course not. It's called boneless, dude. What do you think boneless means? However, let's say that the waiter or waitress knows everything and is honest and says they might. They might. And you go, really? What do you mean they might? It says boneless. Boneless isn't a guarantee that it is without bone. Boneless describes the cooking style. And you go, what? I'm sorry, I'm not a chef. What does it mean, the cooking style? Oh, it means that the chicken's been deboned. Okay, so you got the bones out? No, not necessarily. We tried to get bones out. We probably got most of the bones out, but there's no guarantee that the bones are out. Now, do you want those boneless wings? And that's the point. If the seller was truthful in disclosing everything about what they're selling you, you might not make that purchase. However, when the menu says boneless wings, and you look at it, you go, okay, reasonably, that boneless. If the seller, who's represented by that waiter or waitress, said to you, it still can contain bones. It still can contain bones. There's a good chance, you might rethink your decision. And that's the whole point. I've told people before, I practice lemon law, the defective automobiles. I handle those, and I sue car manufacturers. Over the years, though, if you ask me what I did for a living, I'd often say consumer protection. The broader umbrella is consumer protection. And one of the most important aspects of consumer protection is that at the moment someone is considering a purchase and deciding whether or not to purchase something, do I buy that? Yes or no? Do I buy that? Yes or no? Is how much information they have access to and how much of it came from the seller, and can they rely upon what they got from the seller? Now, I've talked about this ad nauseum, that car dealers, for instance, in Michigan can sell cars as is and disclaim the implied warranty and merchantability and routinely have people sign a document saying, I'm not relying on anything the seller told me. Okay, so if you sign those documents and it's sold to you as is, then you should know that you don't get much from what they said to you, okay? However, let's go back in a moment in time when the person's ordering at the table. They've got in their hands a menu prepared by the seller. It's got words on it, written, edited, and placed there by the seller. And the words describe the food. And the words say boneless chicken wings. And they are now saying that any reasonable person reading that should go, oh, boneless is not descriptive of the amount of bones in the food. It's a description of the cooking style. And as somebody hinted at in this article, shouldn't it say on the menu, may contain bones? See, if I'm expected as a reasonable consumer to look out for myself to some extent, isn't the seller supposed to look out for me also? They're the ones preparing the food. Shouldn't they warn people, by the way, it may contain bones? But here's the thing, that's getting off track already. Because as I said, it's a breach of warranty case. Breach of warranty says if you make an express statement about the goods with respect to their quality or their condition or their nature, and the statement is objectively false, you lose. You lose. Breach of warranty. So how could legislation fix this? Well, there's already the UCC on the books in Ohio. I'm pretty sure there is. However, if they wanted to, they could create a Truth in Labeling Act very, very simply and just say certain things on menus must have disclosures. And so if you want to call something boneless, it shouldn't have bones in it. However, if you want to continue calling it that, you should put a warning that is obvious that the buyer can see that says may contain bones. Boneless is simply a description of the cooking and preparation style. But the bigger concern I have is that we all know that these cases become precedent, meaning that other people can point to them and say, well, you decided that in this case, so you got to decide that in my case. So we're going to get into all kinds of food adulteration issues where people will say, I went to a restaurant and this was in my food and it shouldn't have been there. And people are going to say, yeah, but Berkheimer. And now it'll become the Berkheimer rule. And that is that if you could have anticipated it or you could have avoided it, you've got no claim, even under a breach of warranty theory, which to me is crazy. So do they actually need to create a new law on this? They could. They could create a very, very narrow one just on the word boneless, but they could also create a slightly broader one that says anything that is in the food that is not obvious to the buyer should be called out by the seller. And if you call it boneless, and if it can contain bones, you should put that in the menu and say, by the way, this still may contain bones. By the way, I mean, I think about all the things I see in menus. And I routinely read menus, if I was in a restaurant on Sunday. And down at the bottom is a whole warning about how your food is prepared. You know, if you order your food cooked this way, it might have this issue. If you order it cooked this way, it might contain this. By the way, if you order this right here, it may contain this. You could add one. Your boneless chicken wings might contain bones. So we'll see what happens. Lawmaker takes action after Ohio State Supreme Court rules that boneless chicken wings can have bones. From Morgan Trout, OhioCapitalJournal.com. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. I say good day.